This on? Let's see here. Maybe it is. I would encourage everyone to sit as close to the front as possible so you can see the screens better. Okay. I don't need to say my name. You all know me, so I'll just say a few words of it. Introduction. I never planned to be an estate planning lawyer. When I was in law school, I took an antitrust course, and it was very exciting. I want to be an antitrust lawyer. And then I got to Fresno and went to work for a law firm, and we need someone who does trusts and estate planning, and we hate it, and that's going to be you. So I started doing it and found out this is what I really love to do. So I've been an estate planning lawyer now for more than 52 years, and have worked in a law office for more than 60 years. So I have a little bit of experience in this subject. I'm getting a little bit of echo on this. Maybe you can adjust that a little. Okay, let's see. Is this working? No, it's not. There we go. I would like to begin this presentation by defining a few terms that I'll be using. Estate. What is an estate? Estate is the term that refers to everything that one owns. Real property, personal property, everything. Estate plan is a process. It's a strategic process of organizing, managing, and arranging your estate while you're living for needs that will arise while you're living and for transferring your property after death. Most people have some idea of what a will is. A will is a document that states to whom your estate will go after death and whom you will appoint to be in charge. A living trust is a legal document that states to whom you want your estate distributed and who is to be in charge. But they're not the same thing. They're very different. They're different in regards to when it takes effect and how it will work. A will only takes effect after death. And for it to have meaning, it will have to pass through a process in the division of the Superior Court called the probate court. The probate judge will administer that. This is a lengthy process. In Fresno County, it's average 3 years. Probate is also very expensive. Many people have some sense of that. Now, a living trust is something that is more lengthy generally than a will. It takes effect immediately upon signing it. Its benefits start immediately after you've signed it. And the most noticeable difference takes place after death, because a living trust does not need to go through the probate process. Instead, it is administered privately by the trustee whom you appoint, and whereas probate will take years, as I mentioned in Fresno County, average about 3 years, trust administration, by and large, takes place over a period of 3 days to 3 weeks, and it's done. And in terms of the expense, in Fresno County, I'll give you these figures in just a bit, it's dramatically more expensive for probate than trust administration. Two other words I want to define are trustor and trustee. If you create a living trust, you're the trustor. The person who administers the trust is called the trustee. Very often, when an individual or a couple come to me for creating an estate plan, they will be both the initial trustees and the trustors. But then someone else down the road will take over that role of trustee. Here's more detail on the difference between a will and a trust. Now, I would say maybe 85% of the families that come to me for estate planning have an estate that varies in value from about $350,000 to about $1 million. Now, those numbers include the gross values of your real property. In probate court, if you have a house that would be $500,000 on the market, but you still owe $300,000 on it, in probate, that's a $500,000 house. Now, why is that important? Because there is a state-appointed person who's called the probate referee, whose job it is to appraise properties that pass through court proceedings. And there's two in Fresno County, and their appraisal then is applied to a formula from which we determine what the lawyer for the estate gets paid, what the personal representative gets paid. Well, for a $350,000 valued estate, the lawyer's fee, statutory, is $10,000, and statutory commission for the personal representative is $10,000. So that's $20,000 in basic costs for a $350,000 estate, which is not really a large estate anymore. And then on top of that, there are court costs and extraordinary fees. The lawyers, if they think they can get it, will ask the court to award them extraordinary compensation for this or that thing they did, which is not customarily covered by the ordinary fees. I have seen estates where the extraordinary fee request was larger than the ordinary fee request. And the other figure I put up here is $46,000. That is the basic attorney fee and a basic administrator commission for a $1 million estate. Now, let's compare that with a trust, where the fees for handling a trust when you die are somewhere, when I am informed about it, somewhere between $0 and maybe $700. That's very typical. I rarely charge fees over $700 for what I do in assisting someone with trust administration. And what that consists of is sometimes the trustee then will call me. They know I wrote the trust, and then they say, I read through it, and I just want to confirm that I'm doing this correctly. So it looks like I'm supposed to identify all the property. Yes, that's correct. And then I identify who the beneficiaries are. Yes, I read that in the trust. And then I'm supposed to distribute according to what the trust is. Yes. Any other questions? No. I mean, so the fees tend to be fairly low for that. But compare that with those fees. Now, there's another advantage to having a trust that a will does not provide. As I mentioned, a will only takes effect at death, and its function is to go through probate to ultimately come to the distribution. But a will doesn't do anything for the individual who develops dementia or Alzheimer's disease, or otherwise is incapable of taking care of their property while living. This is another enormous advantage of having a living trust. Are you familiar with the term conservatorship? Anybody know anyone that's been through that process? It's the process. It takes place in the same courtroom where probates are administered, but it's a process for appointing someone to take care of an individual who's not able to manage their affairs anymore. To get there, we generally need a opinion of a medical professional that this person is no longer able to manage their affairs. And so the court appoints a conservator to make decisions and manage money and property. And it's good that we have a remedy, but it's a terrible remedy. For one thing, conservatorship is very costly. The lawyers I know who are doing this now have initial fees just for startup around $7,000, and then it costs about $2,000 a year in attorney fees for the rest of the life of the conservatee, which is very steep. You know, if a person lives a while, those fees might exceed probate fees. And then there's going to be a probate after that. So I've seen entire estates drained with fees from conservatorship and then probate later on. And the other, even greater disadvantage to conservatorship is whatever family member then agrees to serve as conservator will have a record-keeping burden imposed upon them, which is very onerous. I mean, they have to keep track of every cent that is spent for the conservatee and all the money coming in, detailed requirements. I've had back in the day when I did conservatorships, I stopped doing them in 1995, but they would say, I want out. Well, there is no out. Once you're committed to being conservator, as long as the person's living, you're conservator, unless you can find someone willing to take over that off the shore. Well, bottom line, a trust avoids all that. All the authority a probate judge would give to a conservator is contained in your trust. So, a will is going to go to probate. It's going to be very costly. It's going to take, average in Fresno County, 3 years. And if a courthouse file is open, there'll be a lot of personal information exposed to public view. Trust remains private. It's handled in a matter of days or weeks. And the fees involved are very low, and you have the additional advantage of not needing a conservatorship. All living trusts avoid probate and conservatorship, but there are different kinds of living trusts. Now, if you were to come to me and say, we need a trust, what I'm going to set up for you is a revocable living trust. I'm going to say more about that in a few minutes. These are mainly created for efficient administration of one's estate and for the other benefits that I stated a moment ago. I'm going to come back to this. You may have heard of irrevocable living trusts. The main difference in structure between a revocable living trust and irrevocable is really just two things. A revocable living trust is one which you can freely change at any time, and an irrevocable trust is very difficult to change, and some parts of it can't be changed. With a revocable living trust, if you set one of those up, you will be in charge. You will make all the decisions. With an irrevocable trust, somebody else will make the decisions from that point on, and you surrender all control over your own property. So why in the world would anyone want to set up an irrevocable living trust? Well, because this is the device we use to get people qualified for Medi-Cal. Now, under the rules that were in force up to about 2023, you were not able to have very much in the way of property. And so a lot of people needed Medi-Cal, but they had too much, and too much wasn't very much. But they wanted the Medi-Cal. So they found out that you could set up an irrevocable living trust, put the property into that, and then whatever property was in the irrevocable trust would not count against you for Medi-Cal qualification. So as people found out about it, these became very, very popular. And there was the additional issue of Medi-Cal coming and taking one's property at death to pay back the state for whatever they paid out. But if property was put in an irrevocable trust, that would not happen. It would go to whatever family members were designated as beneficiaries. So when people heard about these, irrevocable trusts became very popular. And then in 2023, things changed. One of the last things that Governor Brown signed was a bill that pretty much made it possible to qualify for Medi-Cal for almost everybody without setting up an irrevocable trust. That just having a trust would protect one's estate from being taken by the state of California at death. And so I stopped writing. We call them IDITs. It stands for something. I'm going to call it an IDIT for simple. We stopped writing IDITs because we didn't need them except in a very few instances. If you had real property like rentals that was generating income, that was a problem for Medi-Cal. So I went from writing, well, I did 1,000 of them over the years, and I went to almost 0 between then and then early 2026 when things changed again. I will mention, by way of comparison, I've written approximately 4,000 revocable living trusts, 1,000 irrevocables. So that was the ratio. Well, things changed again. Later in 2023, there were 2 changes in the law. One was a revenue ruling. Have you ever heard of an IRS revenue ruling? You know what that is? That's where the IRS decides they're going to clarify something that's been kind of up in the air over time. And they made a revenue ruling that if a person inherits property through an irrevocable trust, number 2 there, then they will not inherit that with stepped-up basis. I'm going to explain that in a moment. Another change then was the Medi-Cal change, where you really didn't need to do this anymore. So the people who refer this type of client to me and I started making phone calls to 1,000 people that I wrote these for, saying, you don't need it anymore. Undo that, because your beneficiaries are not going to get stepped-up basis. So I converted a lot of IDITs to revocable trusts. Now, what is basis? This is the most difficult thing I'm going to explain today. Basis is an accounting concept, and it is, I'm going to give you an example. First, it's going to be all murky when I give you the legalese. Basis is purchase price plus capital improvements. All right, my parents came to Fresno in '53. They bought a house in '54, paid $15,000 for it. Their basis was $15,000. It remained so, even though property values were going up, basis remained $15,000 until 1965, when they added a room on the house at a cost of $5,000. Now their basis was $20,000, purchase price plus capital improvement. And it remained $20,000 all the way until 2001, when another event occurred, my mother's death. Well, because of the way I had their estate set up, my father got full stepped-up basis to market value at date of death. The market value in 2001 of that house was $115,000. Now he had a $115,000 basis. 6 months later, sold the house. Market value was now $150,000. That was when this was happening, market values. But because he was over 55, he was not required to pay capital gains. But had they sold the house when they were both still living and under the magic age, I think it's 55, and didn't buy a new house, they would have had to pay capital gains tax on the difference between basis and whatever they sold it for. Well, now let's convert that to the estate planning process. So the individuals in this example purchased a house at 4280 North 1st Street in 1975 for $25,000. These are real figures. I compared it. And then they decide in 2026 to gift the house to their kids. What they're doing is gifting not only the house, but their basis. And the value today of that same property is $364,000. So they're giving their kids a capital gains tax problem. And if the kids have a 15% rate, the kids will have to pay $50,000 in capital gains tax because the parents gave them their basis along with the house. Well, this is the problem we have with IDITs, because if someone inherits a property through an IDIT, they're not going to get stepped-up basis. That same example would apply. So that's why I was trying to get people to undo them. But a lot of people would get that phone call, well, no, we have a trust, so we don't need to change it. We'll just keep what we've got, not understanding this problem. I'm glad you're hearing it. Okay. So now the law has changed again, and certain property, You're only allowed to have a certain amount of money if you're on Medi-Cal, so we're doing hybrids now. We're putting the residence in a revocable trust, and we're putting cash up to $130,000 in a revocable trust, and then anything over that we're putting into the IDIT so they can get their Medi-Cal and not have a problem. But anything over the threshold could be a problem for the beneficiaries. Two more kinds of trusts I'm going to mention. You may have heard of each of these. Number 3 is the special needs trust. Anyone heard of those? Yes. A special needs trust is a special type of trust that we set up for an individual who has a disability, and this allows that person to hold assets and receive financial support without losing their eligibility for government benefits. So, very commonly, when someone brings this situation to me, they have a son or daughter or sibling who is disabled, and they're on some kind of program like SSI or Medi-Cal. And they want to be able to leave money or property to this individual at death. But if they just leave it outright, then Medi-Cal finds out about that, and they say, well, you've got $200,000, you pay your own medical expenses. So then they have to spend all that down to zero and then go back on Medi-Cal. Well, that's kind of a waste. So we have the SNT, the Special Needs Trust. We set up one of these and put money in that for the benefit of that person. The state cannot use that towards qualification for Medi-Cal, and they can never touch that money. So the idea is the state will provide the medical benefits, and then anything else the special needs person needs can be paid for through the funds in the Special Needs Trust. And then those who set it up can designate whoever they want as the beneficiaries if there's still money or property in there when the special needs person dies. So that's why we set up those. I've done probably 100 of those, and they're becoming a lot more popular. Finally, Charitable Needs Trust. I don't know if there's anyone in here that would even be in a category where this might be desired, but this is a device for allowing people to have certain kinds of assets to get a major tax benefit from benefiting a charity, like one's church. To explain it will be confusing. I'll just give an example. A lady came to me. She had a little strip mall in East Fresno, and she was getting the rental income from the 5 little stores in the strip mall. She really wanted to sell the property, but the capital gains tax would have been horrendous, so she was stuck with it. And then she found out about charitable remainder trusts, CRTs. And under this, she can place she placed the strip mall in a CRT, and for doing that, got an enormous tax advantage. And then was able to continue, she is continuing to get all the rent from the properties throughout her life, and then at her death, when she no longer needs that, the property goes to her charity. Shrouds don't have pockets. It can be said, someone got it. It can be set up so even the children can continue to receive those benefits. So for certain people that have some certain kind of property, the CRT makes sense. That's all I'm going to say about those. What are the components of a typical estate plan? Well, as I said, if you were to come to me to set up an estate plan with a revocable living trust, it would have certain elements. The keystone element to the estate plan is the revocable trust declaration. As I mentioned earlier, this is where you designate the persons who will receive the estate at the death. If it's spouses, at the death of the second spouse, if it's a single individual, at that person's death. You will designate who will be in charge. There are more documents than just the trust declaration in the estate plan. If that's all we did, we wouldn't be accomplishing much because the trust needs to have assets transferred into it for it to take effect. Any assets that are not included in the trust may be subject to probate. Currently in California, the threshold qualifications for one's estate to go to probate are if there's real estate involved, other than real estate under $54,000 in value, and that's not anyone's residence. That might be a little vacant lot in Calway. I mean, almost all real estate is going to require probate if it's not in a trust or not designated through joint tenancy, but we'll talk about that later. So real estate will trigger probate, and cash assets that altogether exceed $208,000 will trigger probate. Well, almost everyone who comes to me for estate planning will have an estate that would require probate by one or other of those means. So what we need to do then, in addition to creating the trust declaration, is to fund the trust. That is the term that means putting assets into the trust. We fund a trust with real property by using deeds. We fund a trust with your cash assets by instructing your bank, your credit union, or your stockbroker to change the way title is held on the account so that the cash assets will then go to the trust at the time of death. If it's titled in the trust right now, you're set up in the event of conservatorship. See, conservatorship provides advantages while you're living. Okay, I'll just say a word about this. Credit unions are a little different than banks in the way they handle this. Some credit unions, like Golden One, will not put the trust name on the title to an account. But there's an easy workaround because they will designate the trust as a beneficiary. And as the estate planning lawyer, that's all I care about, that at death, then the funds will end up in the trust. We fund the trust with your untitled property also. When I say untitled, I'm referring to your furniture, your animals, your tools, equipment, jewelry. Those things all have value, not like the value of your home, but they have value, and they belong in the trust as well. And so when I create a trust, I, in addition, have an assignment document where you assign all that untitled property into the trust, both present and future. So any future acquired untitled property is covered by that. Another thing that we want to have as part of the estate plan is a power of attorney. You may know what this is. This is a document where one names an agent to be able to transact financial or real property business on behalf of someone who's not able to manage their affairs anymore. It is important that a power of attorney be comprehensive. Some people will go to OfficeMax and get a power of attorney form and think I'm covered. Or they maybe download something from the internet that says power of attorney and think I'm okay. Or even worse, they'll go to a paralegal and have the paralegal draw up a power of attorney. Well, I've seen all of these situations, and then something happens to them. They can't manage their affairs anymore. They have dementia or something else. And then the family tries to use the power of attorney that the paralegal did or they got from OfficeMax, only to find out it doesn't have the right language and doesn't work. This has happened, to my closest recollection, about 36 times with families that have come to me with this problem, and they got a cheapy power of attorney, and it didn't work. And now it's too late to go back and get a signature from mom. So it's important that a power of attorney be very comprehensive. It's going to cover any situation that could come up. Now, a power of attorney isn't necessary for property that's already in the trust. But we use that for other things. For example, new property comes into the estate and the people, individual or couple, forget to transfer it to the trust, and then we would use the power of attorney to make that transfer. Or, like with IDITs, they're not on the screen anymore, like with IDITs, many times the IDIT person, the trustor, had already developed dementia. They weren't going to be able to sign the trust declaration. So we needed a power of attorney for the son or daughter to be able to sign it for them, only to find out the power of attorney wouldn't work because it was not a well-drafted document. I consider it very important to make a very comprehensive power of attorney as a part of the estate plan when I draft them. The next item up here is healthcare directives. Lucy gave a fine presentation to us last week, so I don't need to repeat any of what she said. I'll simply say that when I create an estate plan, a very good healthcare directive is part of it. Next is a pour-over will. Now, if we have a trust, and a trust avoids probate, and a will takes effect, has to go through probate, why would a will be part of the estate plan? Does that make sense? Well, there is a method to the madness, and that is that a will is necessary. It's a special kind of a will. We call it a pour-over will. And the purpose of a pour-over will is to step in the event that the estate, the trust estate, does not include all of one's property. And if the property that's not in the estate is over the probate threshold, and I see this a surprising number of times. So whatever was put in the trust, that's fine. But whatever's not in the trust may then be subject to probate administration. How does this happen? Well, I've seen primarily three ways. People will refinance property, and in the refinance process, the lender makes you take title out of your trust for 3 weeks. And when you sign the loan docs, they'll say, now put your property back in the trust, and most people will. But some people procrastinate, or we'll take care of it next week, and then they never do. And then they die, and the house never gets put back in the trust. Uh-oh, it's going to probate. I've seen it happen 3 times. Another example would be where you inherit something. And some people think, well, we've got a trust now, so if we inherit something, it automatically goes in the trust. No, it doesn't. Anything that's not in the trust has to be affirmatively placed by you in the trust, to be in the trust. And inheritances create this problem. So you have an aunt in Santa Barbara who has no children, and she leaves her house to you and your cousin, and now you're a 50% owner of a property on the coast. You better, if you have a trust, you better put that in the trust. Otherwise, that 50% interest could go through probate. The worst way this happens is that you make a change yourself and forget that all your property needs to be in the trust. So you change houses. I've seen this happen. People come back to me after 15, 20 years. You should bring all your current papers and things they do. I look at the deed, and this is not the deed I created. You moved? Oh, yeah, we sold that house. We bought this new property in Clovis. Okay, well, you didn't put the property in the trust. We didn't? No. And if you died with it like this, that's going to probate. Fix it. I've seen this more times than ought to have happened, but it happens. And the same can happen with an account. Like you open an account, you got a substantial amount of money in there, and then I've had it with Bank of America. That's the last time they're going to mess things up for me. You open an account at a better bank, like Fresno First Bank or California Bank and Trust, and you forget to put the trust name on the title. Well, anything in there could be subject to probate, and I've seen this happen. And the story I like to tell is I set up a trust for a widow who lived in Northwest Fresno. I got her house transferred into the trust, and I gave her instructions to go to her 2 banks and instruct them to change the title over to the trust. It's very simple. I even prepare a letter that they can give. She didn't have to explain anything. The certificate of trust, which is the next item here, is the thing the bank wants to see. So it should be very easy to go in and do that. And she went to Bank of America and did that. She forgot to go to Fresno First Bank. And then a couple years later, she passed. And her sister was her trustee. Now, back then, the threshold for probate was $150,000. So the sister went to Fresno First Bank to draw out the money for distribution. And they said, we don't see anything about a trust on this account. Oh, dear. So she called me and she said, what do I do? And I said, well, if it's below the probate threshold of $150,000, we can use a declaration to get the money out of the account. There won't be any probate. So she went back to the counter and she said, how much is in the account? So help me. $150,067. We were in probate for 2 years. It was very expensive. Lesson, if you have a trust, you need to put your accounts in the trust. That's all accounts, stock, everything. Get my phone to make sure I'm on time here. Oh, I need to move right along. Okay. I've already mentioned that a certificate of trust is the document the bank needs to see. I'm going to go through some questions now. Not questions, but issues that come up. Is there a disadvantage to having a trust? If the cost of setting it up is a disadvantage, then that's it. What does it cost to set up a trust? Well, that depends upon how much is involved with your estate and which lawyer you go to. For what I would call a simple estate, a couple has a house, one property, and no complicated provisions. Average in Fresno County is about $4,800. The range in fees, that would be about 90% of the lawyers, maybe 95% of the lawyers would be between $3,500 and $8,000 in Fresno County. I know of a lawyer in San Francisco who, for the very same thing, charges $40,000 for that. I have never had charges like that. My standard fee for a basic trust for husband and wife is $2,250, and for a single individual is $2,000. And by the way, if you're a church member or a regular attender, I've always given a $200 discount. But you go to whomever you wish. If you wish to have a trust sale. Okay, otherwise there is no disadvantage to having a trust. It's only advantageous. How should we select our trustees? This question was asked to me this morning just before we started. That's a very difficult decision, and you think about who would be responsible, who would not procrastinate, who would be conscientious about taking on that duty. I have seen people make bad choices of trustees, and we had some negative consequences. So that's a very important decision to make. Can the trust be amended? Well, if it's revocable, yes, it's freely amendable. Can we add property to the trust later? Well, if there's new property that comes into your estate, absolutely you should add that property to the trust. I've heard people say, well, we have a little account in Nevada, $15,000, we just want to leave that out. Why would you want to leave it out? We're setting up the trust for the purpose of avoiding probate. That $15,000 account in Nevada, I don't know what Nevada's rules are, but you put everything in the trust. Can our trust be contested or challenged? Well, yes. Anybody could file a will contest. The more important question is, would it succeed? Any trust that I've written, or any will that I've written, has always had a no contest clause. And in California, unless the individual who's contesting has probable cause, which is pretty difficult to establish, then the will contest or trust contest is going to fail. And if there's a no contest clause, the result will be they're disinherited. So it has a chilling effect on people filing will contests. I wish I had the time to tell you the story that happened in our office. I'll see if I have time at the end. about will contest, a trust contest? So mostly the answer is no, a contest is not going to succeed. Does a trust protect us from lawsuits? That's not what it's for. It's not an asset protection device. It avoids probate. That is its purpose. If you're interested in protecting your estate from lawsuits, there are some lawyers in Los Angeles I'd be happy to refer you to, and their retainer starts at $40,000 and goes up from there. This is mostly for the very wealthy. 7, how will our survivors know what to do? Well, hopefully, if you have a trust, you will have shown them the trust binder. Shown them the trust binder. This is where we keep it. This is whom we've appointed as our trustee. They will know those things, and hopefully the trust is well enough written that it will explain itself, and they'll know what to do. In the trust that I write, I also include an FAQ, a frequently asked questions, which has got about 110 questions I frequently get. So it tends to answer the questions that come up among the children. 8, is a California trust valid in other states? Well, there's something in the Constitution called the Full Faith and Credit Clause. And if it's valid in California, it's going to be valid everywhere else in the country. I have a lot of clients that move to another state and they worry about this. I had some clients that moved to Alberta and I found out they don't have the same kind of trust law in Canada as we do, so it wouldn't be valid there. Should we include our family business in our living trust? Why wouldn't you want to? I mean, I get this question occasionally. Yeah, you include all assets, even businesses. Even if you have a corporation that you own, you would include that. Can our trustee refuse to follow the trust? Well, theoretically, yes. The trustee could decline to follow the directions you've given in there, but if the trustee does that, they're probably going to be hauled into probate court where they could face sanctions, serious penalties, and in some situations, even criminal liability. So trustees tend to follow what the trust says. I get asked this question. Can they decide they don't like one of the children and then just refuse to distribute to that child? They better not try that, or they'll end up facing severe penalties. So they will follow the trust. Must our trustee hire a lawyer after the trustor has died? Well, there's nothing in the law that says you have to. Some people don't, because they figure it out from reading a well-written trust. But as I mentioned earlier, some people just feel more comfortable getting a little guidance. So very often I'll get a phone call, and if there's one situation, if one of the trustors is living at the date of death and still a trustee on the trust, then there's a document called an affidavit of death of trustee that we need to prepare and record downtown. That's very simple. And when I do those, maybe it's $400 or $500 of expense, including the recording fee, and that's about it. Can we name a guardian for our minor children in the living trust? Well, you can name a guardian, and I highly encourage that if you have minor children, but we don't do it in the trust. That's one of the functions of the pour-over will. You appoint a guardian in a will, not in a trust. But yes, you can, and you should. Will our taxes go up if we create a trust? Well, what taxes are we talking about? Income taxes? Property taxes? The answer is no and no. When you create a revocable living trust, it's the same as you continuing to own the property in your own name. The property taxes don't increase, and there's no difference in income taxes. In fact, people say, well, will our accountant now have to file 2 sets of tax returns when we have a trust? No, because it's a revocable trust. It's you. And so you would continue to file the same Form 1040 and 540 you always have. It really doesn't change much in your life. I tell people, after we get this set up, you are scarcely going to notice anything has changed. If your checks if you put your account in the trust as you should, and checks have the trust name printed on it, you'll notice it there, and then once a year you get notice from the county about your property taxes. It'll say something about trust on that. Otherwise, you probably just won't even notice it, except that a very important change will have taken place in your relationship, the relationship of your estate to the probate court. And hopefully you'll remember, we have a trust now, so any new asset should be titled in the trust. Is the trust expensive to maintain? No more expensive to maintain than maintaining your estate the way you have it without a trust. There's no special requirements. There's no annual fees. Will the trust become worthless if the lawyer dies? I get this question. This is probably the number one question I get. Well, you're kind of old. So like, maybe you're not offending me. I know what you're thinking. Maybe I'm going to retire next year, or maybe I'm going to drop dead next year. Are you out of luck because I created the trust? No, because any lawyer who knows estate planning can look at a well-drafted trust and be able to advise you on it, prepare an amendment, whatever you need. We follow a format that's been used for 500 years, and so there won't be any problem with that. Well, what about the other part of the question? Will it become worthless if we lose the documents? I address this by creating a PDF of the entire trust binder for you if you come to me. So I email you a digital copy of your trust. So if you lose the binder, you've still got the digital copy, and I save the digital copy. But even I've seen situations where I was not the one that created the trust, and the mom and dad have died, and the kids have looked everywhere. We have no idea what they did with the trust, and we've got this real estate in the trust. What do we do? And I tell them, well, there is something we can do as long as one of you is living, and we create a new trust. If they have something to show that they were trustee, maybe they don't have the trust, they have something, we can sometimes then create a new trust and put the property in that. Well, the property's already in the name of the trust and then distribute that way. It doesn't always work, but I've done it successfully. This kind of segues into another issue, and that is, what if you have named trustees that have all died before you died? I've had this happen, where the son came to me and there was lots of property in the trust, and the lawyer who created it was in Modesto, and he named, the mom and dad named a couple of their friends as their trustees, and their friends predeceased them. And then at their death, then there was no trustee to distribute the property to him. So he said, what do I do? I said, well, we're going to file a petition. You live here in Fresno. We'll file a petition in the Superior Court in Fresno and name you as the new trustee. And that worked fine. It took 8 months, but he got appointed, and then he was able to distribute the real estate to himself. So there is a solution in that situation. But it's a good idea to take good care of your trust documents if you have a trust. So, one more page here. I call this very good advice. Estate planning on the cheap often leads to bad results. I have seen it many times. In fact, Friday, 2 days ago, I got a phone call from a gentleman. He said, I wish I'd known about you earlier. He only got referred to me last week. The father, to try to save a little money, went to a paralegal to set up a trust. He knew that he needed one. He had, 5 parcels, something like this? And the paralegal kind of messed around, and they got something together. No, that's wrong. It had to be redone. And then the paralegal made another try, and it has to be redone. It was just not right. And then the dad started going downhill, and he didn't have the strength to go back and sign any documents. And then he had a heart attack a week ago, and he passed. Nothing got signed. The son called me, and he said, well, the paralegal at least typed this up. Is that worth something? That is worth nothing. they have no trust. That's going to all have to go to probate. One of the problems with paralegals is they don't have the proper training. And so I have seen trusts they put together that were all messed up. There was someone who used to be in this church that brought her paralegal drafted trust to me and said, could you look at it and just see if it's okay? I said, okay, I'll look at it. I said, what was important to you? Well, my kids get the house. The paralegal had made such a mess of this thing, her children weren't even going to get the house. It was so badly worded. Of course, I fixed it, but going to a paralegal is not a good idea. And I gave you other examples of taking the cheapy route, getting a power of attorney through OfficeMax or some other means. There have been enough disasters here that I've learned that having it done right is worth the expense of having a trust. Finally, can we avoid probate by transferring our property to our kids? I have no idea how many times I've seen this happen, but it's many dozens of times that people come in and I find out they wanted to avoid probate, so they just transfer the house to their kids. Remember how I explained basis to you? They were transferring their basis to the kids too. And what I almost always ended up doing was having the kids, if they would agree to do it, transfer the house back to the parents so the kids could then inherit the house and get the stepped-up basis. I didn't think I was going to finish before 12, but I did. So if you have questions, I'll say, we'll go to 12. I'll answer as many questions as you have, and anyone's question that does not get answered, I'm willing to stay after 12 to answer all general questions. Roger.
Does refinancing your house change the basis?
No. The basis is purchase price plus capital improvements. Refinancing only has to do with liens caused by a loan. Good question. Other questions? Yes.
Can you tell the story that we didn't have time for?
Yes, the no contest clause. It was a Fresno agribusiness tycoon, very, very wealthy. He was a client of the firm that I went to work for in 1965. It's more than 60 years ago I've been in the law business. And he had his trust set up so that it would go to the son and daughter at death. Now, he had a housekeeper, and she did all the unpleasant work, wiping him, vomit on the floor and all that. And he was senile by the time I came on as an attorney in the firm. Well, the son and the daughter didn't come around very often, and the housekeeper's thinking, I should have all this. I'm the one that's doing all the wifely duties. Now, he had put a provision in his trust, leaving her $500,000. But compared to the overall estate, that was pennies. I should have the whole thing, she says. So she takes him to Las Vegas and has a marriage performance. Yes. And she comes back to Fresno, and she calls the son and daughter, and she says, don't come around the house anymore. This is mine now. I'm your stepmother, and you are not welcome in my home. About 14 minutes later, we got a phone call in the office. What can we do? Well, we'll file an annulment immediately, and this will succeed. So we filed the annulment. She was served with papers. She said, uh-oh, I got to run out the clock. I got to live until he dies, and then it's mine. So she hired these unsavory characters and got a van, and they put the old man in the van, and they took him to Arizona. And the FBI was involved. There was a high-speed chase in Phoenix. Yes, this really happened. They found them. They brought them back to Fresno. The stress of this whole thing killed the old man. He died. So she figured, it's mine now, because I was still married when he died. Well, of course not. Annulment case would go forward. So she went to a lawyer. She had a copy of the trust. She showed it to him. He read it, saw the $500,000 that was left to her. He said, now, it's mine now, right? He said, no. She said, well, I could contest the trust. I'm the wife. I've got standing to do this. I mean, she didn't know the word standing. Basically, I could do this. He said, you could do this, but if you lose, you're going to lose the $500,000 because that's what a no contest clause means. So I've got good chance to win, don't I? He said, no. Give me that. Out the door, and that was the end of it. The marriage was annulled. True story. Anyone else have a question? Yes.
I hope to explain it. It's my personal situation. We have a living trust. Paul wanted to have it.
Hold it closer to your lips.
We made it many years ago. And according to this living trust, the house, as far as I understand, I never read it. After we signed it, I forgot what's in it. But the house goes to his children. And there are 4 of them. And we never thought about such situation as I'm thinking now. And what if I'm not going to live in that house to the end of my life? If I will be pretty old, I'm already not that young, and I would like to move to the retirement place.
Okay, I understand your question. What can you do?
What can I do?
These clauses almost always have special provisions in them that spell out what the circumstances are, what would trigger what result. And so to be able to answer your question, I'd actually have to read that paragraph in the trust. It would probably answer your question because it's not one size fits all. Not everyone's situation would be the same.
Yeah,
I would have to see what the trust says.
I'm thinking, should I have renters
Well, it depends upon what the trust says.
and have this headache?
If you want to bring
I
that
would
paragraph,
rather transfer them to the children.
yeah, you bring the paragraph and show me, I'll tell you what it means.
Okay.
That's the only way to answer that question,
Thank you.
because they vary. Up in front, MJ,
Jeff,
right up at your left.
I had a trust drawn, my husband and I had a trust drawn in Arizona 21 years ago. Do the provisions of that trust still apply in California?
Yes, an Arizona trust will apply in California. I've seen Arizona trusts from time to time. Their laws are, in many respects, very similar to California's, although we have some unusual provisions. But yes, that should apply here. I have the reverse happen quite often, where I draft a trust and then the family moves to Massachusetts or Illinois, and they say, is this still going to be good? And in most instances, yes. There is a little interstate variation. I know there are some families here that have Pennsylvania roots. Pennsylvania has an estate tax, whereas we don't in California. So there are some certain states where one might want to have a lawyer look at it. But as far as bringing Arizona trust here, it should be fine. Lenore.
This is not a question, but we have a trust that you made for us. I know exactly where it is. I don't remember all the details, and a few things have changed. So this is a really great reminder to us to take a look and make sure we're up to date.
I'm glad you asked that question. I find that after 15, 20 years, many people have had a lot of changes occur. Maybe not a lot, but certainly changes that require re-examining the estate plan to see that it's all correct.
My clock has us pretty close to noon, so thank you very much to Jeff for your expertise sharing that with us.
Thank you.
Next Sunday will be the final in this series. Pastor Audrey will be back talking about memorial services. If, for instance, we sang one of your favorite hymns that you would really want played at your service, this would be a great time to be able to note things like that. Or maybe today we sang your least favorite hymn. You were crawling in your skin. You hated it. Don't sing it, or I'm going to come up from the grave and chase you down. Or other things, maybe bits of your life story, poems, all of those sort of things. Thinking about a memorial service, what goes into that? Pastor Audrey will talk about that next week. Hope you all have a good week. Thank you again, Jeff.
Brian, if anybody has a question they were embarrassed to ask, I'll stay for a few minutes and answer those questions.
Since we're out of town next week, will that be something we can watch later?
It will be recorded. Yep.
That will help. Yes, I certainly do. Yeah, you have a title to a house? Okay, yeah, you need a trust.
Okay.
Thank you for asking. I certainly do.